name's Lewis O'Brien. I've created this 5-minute guide series to property development contracts to help those who want to develop property, be it a small renovation or a large unit development, to avoid common mistakes and do it better. Our goal is not only to help you avoid an expensive car crash, but to give you ideas and techniques that will help to make your next development more profitable. In this video, we're going to talk about Deeds of Partition. Many of my clients are familiar with the concept and aware of the idea that you can use Deeds of Partition to minimize or avoid stamp duty. However, it's important when using a Deed of Partition that we get the details and timing right, and that we're aware that there's a limited window to put them in place. For example, they only work if they're signed and put in place before settlement. As always, this advice is relevant to the state of Victoria and current as of January 2022. So let's talk about exactly what a deed of partition is. It is a written document that specifies that part of the land is held for the benefit of another party. That other party might be one of the purchasers, or they might not be. But it is clear that in the deed of partition, we need to identify who that party is and exactly which part of the land is held on their behalf. In essence, it's a form of trust deed. So the purchasers on title are declaring that they hold the property as trustee for the identified beneficiary. There is a limited window of opportunity in which a deed of partition can work. It is critical that the deed is put in place before you settle the purchase of the property. This concept will not work once you've settled, because the declaration of trust would constitute a transfer of the land. We need to know exactly who the beneficiary is. That is, who's going to receive the identified part of the land. And we also need to identify that land very carefully. Generally, that means we need, if not a draft plan of subdivision, something fairly close to it so we can identify accurately with measurements which part of the land is going to be transferred to the beneficiary. Next, let's explore exactly how a deed of partition works. So we've set up our deed, we've signed it before settlement, we've identified effectively the beneficiary and the land involved. Sometime later, so we've settled the purchase, presumably we've built our development, we now want to give effect to the deed of partition. So essentially what we're doing is transferring that newly subdivided part of the land we've identified to the identified beneficiary. We then go to the State Revenue Office and say that there is a deed of partition in place. Effectively, there's no change in the beneficial ownership of this land, therefore there should be no stamp duty. The application to the State Revenue Office will be assessed as a complex assessment. That is, an individual will actually review it, so it's important to get the details right. Let's look at a couple of examples where a deed of partition can work quite well. An obvious example is where we have 2, 3, or 4 parties who are jointly developing a property in the expectation that once the development is complete, that they will actually retain one of the completed units. We can use a deed of partition to ensure that when the development is complete, that units can be transferred to each of our joint venturers without paying further stamp duty. Another example might be a case where a developer is developing 3, 4, or 5 units with the intention of keeping one of the units once the development is complete, but in a different structure. So the developer completes the development, sells off the first few, and the last one can then be transferred using a deed of partition into a separate long-term holding structure without paying further stamp duty. In putting a deed of partition together, there's a number of traps to avoid. First and foremost, we need to make sure we get our timing with nominations right. The first thing to do if you're nominating is to do the nomination first, then prepare your plan of subdivision, then put your deed of partition in place. If you get that order wrong, you may well incur significant additional stamp duty. The timing and the details here are incredibly important. Bear in mind that when you actually give effect to your deed of partition, it will be assessed by the State Revenue Office. So if you have made errors along the way, these stamp duty problems can come home to roost. If you are interested in a deed of priority, please contact Lewis O'Brien and Associates. we can assist you with the deed of priority and your general structuring requirements. This will help you avoid unnecessary problems, but more importantly, we can help to expedite the process and potentially add profits and to your overall project. Please contact us and ask how our expertise can help improve your next project. That brings us to the end of this video. If you've enjoyed this video or learnt something from it, please share the video with a friend. Or like the video by pressing the appropriate red button, and subscribe to our YouTube channel. Or you could subscribe to the newsletter available at our website, lewisobrien.com.au. Thank you for your time.